Hi everyone, good evening, all of you. Welcome to the session. Today we are going to start the corporate and business law. This is the Akanksha Somani, and I am going to teach you the global variant of your paper F4, which is corporate and business law. Let me know in the comments who is present in the class. So friends, the first topic is essential elements of legal system. But first of all, let us understand the subject. What is there in this subject? So in law, we have many variants available, but here we are covering global variant of corporate and business law. Global variant we are studying. Now here we need to understand how the pattern will be in the examination. Though it is a paper from your skill level, but the pattern it follows is similar to your knowledge level paper. This paper is also an on-demand paper. On-demand simply means once you are prepared, you can book an exam as and when you want. That is on demand. Good evening, Rahul. Also, the weightage of the paper will be of 100 marks. For passing, you will be needing 50% score. 2 hours exam it will be. Here, the result will be announced immediately after you submit your paper, and the questions will be MCQs and MTQs only. So you are not supposed to give any kind of descriptive paper in this particular exam. So that is the best part about this subject. Hello, Akriti. Hello, Jewel. How are you all, students? Good evening. So that is how this paper works. It is purely an on-demand paper. All the questions will be in the form of multi-choice questions or multitask questions. You will be given 2 hours to attend this paper, and results will be in your hand immediately after you submit the exam. Good evening, students. Welcome to the class. This is the first class of your corporate and business law. In this class, we will be covering economic systems, types of law, role of judges, what is common law, what is civil law, what is criminal law. So, basics of law we will be covering in this particular session. So, first of all, we need to understand there is an economic system in a country, there is a political system in a country, and there is a legal system in a country. Economic system simply means the demand and supply that governs entire demand and entire supply for the nation. So that comes under the economic system. Political system is how the country is ruled. That is what political system is. For example, in India, we have democracy. So that is its political system. Legal system means how the laws are implemented, which kind of laws are applicable in a specific nation. That is its legal system, and all the things work together. Political system, economic system, legal system, they are influenced by each other. Now, first of all, we need to understand the types of economy we find in a system. We have planned economy, market economy, mixed economy. Tell me in India which economy is being followed in India. Planned economy means something that is purely in the control of government, that is planned economy. Okay. So where government decides everything, government take cares of everything, that is a planned economy. Market economy means government is not ruling the economy. Economy is governed by the market situations, market demand, market conditions means government is having least control over the things. Mixed economy means few things are in the control of government and rest of the things are decided by the market. So tell me in India which system we follows. In India we have mixed economic system because we can see a few things are in the control of government, like if you say electricity, gas, the basic necessity things are usually regulated by government, but again there are private sector markets which are not regulated by government. So we have a mixed economy. In planned economy, everything is in the control of government, like in North Korea. In USA, they are purely running their economy based on the market forces. That is a market economy. Is that clear, everyone? Can we go ahead? So three types of economic systems we have. Let's make a short note. Types of economic system. The first one is planned economy, is regulated by government. The second one being market economy, which is regulated by market forces. And the third one is mixed economy. Mixed economy simply means few things are controlled by government and few things are in control of. Few things are controlled through market force, like we have in India. Please write down this note, and once it is finished, let me know. Just a minute. Is it done, students? Have you written it? Okay, let's go ahead. Now comes the political system. Political system is how any region or how any nation is governed. That is its political system. Who holds the authority within the society and how they get that power. It is the influence of government on the economy, the role of religion in any country. So we have various types of political system like monarchy, anarchy, democracy, republic. All these systems we will be learning here. The first system being monarchy. Monarchy is the one of the oldest system where everything was decided by a king, the ruler, and the ruler was not appointed by the citizen. The ruler was by inheritance. The oldest form of political system is monarchy, with society being headed by a single ruler. Whether the society is a tribal group or an entire empire, in modern usage, the term means a system headed by a single hereditary ruler. Now, this ruler is not appointed by the people, this is not voted for by the people. This ruler is purely by hereditary. For example, in India, there were Mughal empires. So, that was the monarchy system. There was a sultan who was ruling an empire. So, that is the monarchy system where all the powers are with a single ruler. Republic. Republic means a system where president takes the decision. The head of the state is a president, and this president is a non-monarch. Means this president is not someone who is a king, sultan, or something like that. The president acts as the head of the state or the country. Then comes theocracy. Now, theocracy is a system that simply means everything is guided by divine power of God. Means there is no separation between the government and the church. There are no separation of church from the government and recognize the God or a deity as supreme ruler, or the state is governed by divine guidance or divinely guided official. This they simply means we don't need something like ruler or something. We are governed by the divine power, divine instructions of the God. That is theocracy. Totalitarianism. This is the system where government is having unlimited power to decide all the public and private aspect of life. In totalitarian system, the state has unlimited authority. It aims to control all aspects of public and private life. The population has little or no say in the matters and often no electoral right, means there is no election right. So this system is when there is a presence of single leader or one single political party and there is no opposition, a strong political ideology through state control. So a system which is deciding public as well as private matter. Now let us understand this. For example, if Mr. B and Mr. A are having a dispute. Now, this dispute is resolved by the court, means government won't be interfering in their dispute. They can resolve it on their own, they can discuss it and they can resolve it. But totalitarian system means public matter will also be decided by the government and private matters will also be decided by government. Everything is in the control of the government. Democracy, which we are having in India, it is by the people, for the people. People vote in the election and their elected authority will become the leader of the nation. Democracy originated in Greece under the citizen enjoy personal freedom. The electorate have choice over whom to vote for. Usually two or more political parties, they have candidates for elections. The Westminster model. The Westminster model is a mixture of monarchy plus democracy. So how it is a mixture? They are having a king as well as, just like in democracy, there is voting by people and there will be full and there will be members who are elected by the people vote. So it is modeled on the system which operates in UK. The Westminster system is a democratic parliamentary system with features which include a sovereign. Sovereign means there is a king or head of the state who is separate from the head of government. So there is a king as well as there is a government. The government is drawn largely from legislature. There are two chambers, like we have Lok Sabha and Rajya Sabha. In UK, there is House of Commons and House of Lords. In House of Commons, members are elected, means people go in election, people vote, and the candidate who gets the maximum vote will be elected in House of Commons. In House of Lords, members are not elected. The sovereign, the king, is a figurehead and also holder of reserve power. Means there are certain power which are reserved for the king in this particular system, such as formal responsibility for appointing prime minister. This prime minister will be appointed by the king and asking them to form a government. Opening and dissolving parliament will be done by the king. Approving new legislation will be done by the king. Then comes anarchy. Anarchist theory promotes the absence of compulsory government. This model, by its very nature, is unsuited to more than small communities. Now, this system believes government is not needed. We can manage ourselves. No government is needed. So, it is suitable for small communities only. So, these are the types of political system we have. Political system simply means, please write down the notes, how society is governed or how the state is governed. Okay. Here the first one was monarchy, when state ruled by a king or sultan. Their power is due to inheritance. That was the first system. Okay. Second one was republic. Republic means governed by president. Raja, this session is purely for the students who wants to learn in English. If you want to learn in Hindi, there are lectures available on the same channel. Ritesh, global or English mein there is a difference. The difference is in global law, we study about international rules and regulations, and in case of English law, you are specifically studying the law of UK only. Theocracy means there is no separation of church and state. Okay. Then we have anarchy. Anarchy means There is no need of government. Ritesh, if you are specifically thinking to move UK, you should study English law. But if there is no specific plan like that, you can go for global law. Then there was democracy. Democracy was for the people, by the people, ruling bodies appointed through elections. Okay. Then there is totalitarianism. Totalitarianism means ruling body having unlimited power. Govern all aspect of life. There is no opposition, single political party. Okay. And there was this Westminster model. Westminster model is a combination of monarchy plus democracy. There is a king plus there are elected people. In democracy, they are having the houses of parliament like House of Commons, House of Lords. Please write down this note. राजा आप दूसरा लेक्चर देख सकते हैं जहाँ पे पूरा टॉपिक हिंदी में कवर्ड है. So this lecture is specifically for students who wants to learn law in English. Once it is done, let me know, students. Is it done? Mahi, this is law subject. The three branches of government. Government is having three branches: legislature, executive, and judicial. Legislative branch makes the law. Executive branch implements the law. Mahi, don't spam. And judicial branch does the interpretation and resolving the disputes. So legislature branch are the lawmakers. They are responsible for creating, amending, repealing law. Means they make the law. If there is any change which is required, they do the amendments. Repealing law means some laws get old, so those law require repeal. While they draft and vote on the legislation, their bills typically require formal approval from executive to officially becoming law. For example, those who are making law, they will also need approval from executive wing. In India, a law is passed when it is passed in parliament. That is, parliament is your legislative wing. But again, in executive wing, president's signature is required, then only law becomes complete. So here we can say that Law is made by parliament, but law is signed by president. Okay. So that is the first wing. Now the second wing is executive wing. Executive wing implements the law. Mahi, this subject is there in ACCA. It is corporate and business law subject, paper number F for global variant. The executive wing, the law enforcers, they handles the day-to-day administration of state and ensure that law passed by legislature are implemented and enforced. So they are responsible for ensuring that law is implemented properly, law is enforced. For example, executive wings include president of the country or prime ministers in some country. The third one is judicial wing. In this wing, we have all the courts like Supreme Courts, High Courts. They are in judicial wing. So basically, they are responsible for resolving legal dispute. If any dispute will be arise, in that case, Supreme Courts will resolve those disputes. So there are three wings of government. So here we can say three wings of Indian government. First of all, we should be going for legislative wing. Legislative wing is your parliament which passes the law like Lok Sabha and Rajya Sabha. Executive wing. Executive wing simply means that those who implement the law like president, vice president, cabinet minister. Judicial wing. It consists of Supreme Court of India which solve the conflicts between executive and legislature and other related matters of conflicts. So there are three wings of government that we need to understand. And the topic is quite easy. Three wings. Let's make a note of the three wings of government. The first wing is your legislative wing. Legislative wing makes law. The second one is executive wing. Executive wing implements law. Raja don't spam. And the third one is judicial wing. Judicial wing resolves disputes, interpret law. Please write this small note about the types of wings we have. Please write a note on the same, and once it is done, let me know. Is it done? Done, everyone? Can we go ahead? Just a minute, I have to take an urgent call. The next topic is your legal systems. We have different types of legal system. The first legal system is civil law. There are three major systems: civil law, common law, religious law. Now, what is civil law? Civil law is something that is properly written, properly codified based on written constitution and codified statute rather than judicial decisions. Now, what are judicial decisions? Judicial decisions are decisions by court. Judicial decisions are decisions by court. So sometimes we can follow the old decisions of the court as a part of the law, but civil law is not made up of judicial decision. It is based on written constitution, means something that is properly written in the constitution. Codified statute means the proper law which are passed by the parliament. So civil law is something that is properly codified, properly written, and not just based on judicial decisions. It is most widely used system found in most European Union countries, the Commonwealth of Independent States, Africa, South America, Far East, all these countries are following civil law. Now, what is common law? Common law is an English law or judge-made law. Judge-made law means a law made by judicial decisions of courts, where we simply follow the decisions given by the court. So, in this system, judicial decisions are central. Courts play Courts play a key role in interpreting and applying the law. Common law originated from English legal thought and adopted in countries like USA, Australia, India, Canada. Everywhere we are following common law. The main basis of common law is judicial decisions of the court. Now, religious law. Some law are simply based on religious beliefs. Some countries base their legal system on state recognized religion. The most widespread is Islamic or Sharia law, which is also a part of this chapter, which is followed in the countries like Saudi Arabia, Pakistan, which applies principle from Quran and other religious texts. Sharia provides rule for public and private life, covering politics, economics, banking, business, contract. All these things are covered in religion. So Sharia law is followed in which countries like Afghanistan, Saudi Arabia, Yemen, Morocco, Pakistan. That's where they are following Sharia law. So we have three types of legal system: civil law, common law, and religious law. Branches of law, we have two branches of law: criminal and civil. Criminal branch take cares of the matter which state wants to stop. For example, criminal law covers matters like murder, theft, fraud, and civil law is dispute between the people. So we can say criminal law covers the matters which affect all the people in general. Like if there is a criminal who had murdered someone, that criminal can murder someone else too. So that's why it is covered. Here case is filed by government, means government file a case against the criminal. Here the people who wants to claim something, who is usually known as claimant. The next one, if we talk about, here we need a proof, and proof should be beyond reasonable doubt, means there should not be any doubt. That's great, Sujal, congratulations. And in case of civil law, we can simply say ki proof can be on the basis of probabilities, decisions can be given. So we need to understand the difference between these two very well, because it is a good topic which can be asked in the exam. Criminal law deals with the conduct which state disapprove of and seeks to control. Okay. And civil law is between the disputes of and deals with the dispute between individuals, focusing on compensation, remedies, and all these things. So we have three types of legal systems, types of law, and branches of law. In types of law, we have civil law. Civil law is written statute, codified law, constitution, means properly written everything. That is how civil law is made up of. Common law, we can say judge made law, which is based on judicial decisions of the court. Based on judicial decisions of court. Okay. Now we have the third one is your religious law. For example, Sharia law. It is based on religious principles. In branches of law, we have two main branches, criminal and civil. Criminal branch covers the matter which government want to punish. Okay. Then we can say the next one. Here, case is brought by government. Proof should be beyond civil law. It covers individual disputes, contractual disputes. Case is brought by claimant and proof should be on basis of probability. Write it down. Once it is done, let me know, students. Is it done, everyone? Have you written these notes? Because this topic is important. Can we go ahead and study this topic of civil and criminal law? So let us understand the difference. Criminal law is something that state disapprove of something illegal and punishes, while civil law is about private disputes between businesses, entities, individuals. The primary purpose of criminal law is to regulate societal behavior, and for civil law is to resolve the disputes. Who files a case? In the criminal law, the government file a case, the prosecutor file a case, and the name of the case will be like R versus XYZ. R versus means R means king or queen, XYZ means the person against whom the case is filed. But in case of civil law, the claimant will file the case. The claimant means this person with whom the wrong is done, who wants to claim something. Burden of proof rests entirely on the prosecution. Here it rests entirely on the claimant. Standard of proof. In case of criminal law, we need a very high standard proof and must be almost certain. But in case of civil law, low standard proof will also work on the balance of probabilities. The core purpose of criminal law is to punish the offenders and stop the crime. The civil law's core purpose is to remedy and give compensation to the victim. In criminal law, if a person is guilty, there will be prison, fine, and community service. And if they are innocent, they will be released by the court. In case of civil law, if a person is guilty, they have to pay damages, or there will be stop order by the court or specific performance of the contract. So, real world examples, if we see like prosecution of a theft, retail theft, or an assault, these are something that government disapproves of. And obviously, if a person can do theft at one place, they can do it other place also. That's why government is concerned. Civil law example are like breach of a contract, or there is a dispute between seller or buyer regarding the quality or the price of the goods. Now let's know more about civil law. Originates from the Roman law, which was written, codified law applied by judges. After fall of Roman Empire, the Roman principles still continued. During alignment and rights of nation states, emphasis returned to clear, uniform legal codes. So generally in civil law, which codes are being followed? French civil code, German civil code. What are the main principles of civil law? The first principle is comprehensibility. The law are drafted in codes to cover all kind of situations. That is the first thing. Certainty means you are not doing decisions based on the probability. There is a certainty, there is a written law on the basis of which you are supposed to give the decision. So decisions are based on written code with judges having limited interpretative power. Sources of law in civil law systems. The first source is constitution, which is fundamental right. Every country has its own constitution. That is the first source of civil law. European Union. It is a union where many countries are members. So European Union is law is also a part of civil law. Statutes are the written law which are passed by the government. Administrative rules and regulations and customs which are followed since long time. So these are the sources of making civil law system. Now how the case names are written. For example, there are two parties, Mr. A and Mr. B. A supplied goods to B and B was supposed to make payment. Alright. So here A supplied the goods and B was supposed to make the payment. In this case, A had supplied the goods, but B is not making payment. Now, A is the party who is aggrieved, who is in trouble, who is not getting his payment. So, A wants to claim his money. So, A is claimant. A will file a case. Now, how we will write this case? It was a case between A versus B. Means A is the claimant, B is the dependent. In case of criminal cases, it will always be like R versus whatever the person's name is. R means king or queen. King or queen means government. So in criminal cases, the name will be written like this. And in civil cases, both the parties' name will be written. Whosoever files the case, that person's name will be written first. And against whom the case is filed, that person's name is written in the second. Too early. It's too early for a tea break, isn't it so? Now, what are the role of judges in civil law? When law is properly written, judges have limited power. When something is properly written, judges cannot add the things on their own. Judges do not draft the law, but they can create precedents that other judges follow. Precedent means judges can pass the decisions which other judges can also follow. Now, principles of judicial interpretation, judges apply the law rather than interpreting it. They interpret law by considering the social purpose, historical purpose, adapting to modern situation. So when judges study the law and give interpretation, they look for everything around it. We are again discussing the same topic which we have discussed earlier. We have three types of legal system. The first one is civil law, the second one is common law. Civil law is something that is properly written, means judges have limited power. They cannot give any kind of interpretation. They are supposed to read the law and interpret what is written in the law. In common law, it is purely made by judge made law. Judge made law simply means based on the decisions given by the judges. In civil law system, one only has to look in the appropriate code to find the law relating to that area. However, in a common law system, one has not only to look at the legislation made by parliament, but also in cases for judicial statement that actually constitute that common law. So common law developed in medieval England when crown appointed judges traveled the country, hearing cases, applying consistent legal principles. So this was derived in the long time, medieval time, very earlier period where judges used to go from country to country or places to places to hear the cases and give the decisions. So what we want common in the common law, we want a uniform common law which can be applied across England. Now, common law was later exported to British colonies, trading partners worldwide, and it is purely based on case laws. Case laws means the law, the cases which are decided in the courts. Law developed by judges through decision in individual cases. Case law means judicial interpretation, explanation, and application of law in specific cases. The system introduced juries to decide question of fact while judges rule on law and pass sentences. Juries remain central. Juries means group of judges. They are important for criminal trial. Means if there is a criminal case, we need a jury. We can't rely on a single judge. In some countries, juries are also used in civil cases also if the case is severe. Now, what is the role of judge in a common law system? The duty of judge is not to make the law but to identify, interpret and apply fundamental principles of common law and interpret statutes. The general rule is that precedent set by higher courts bind the judges in lower courts. Now we are reading something important again. What is this thing? For example, a decision is passed by Supreme Court. Will this decision be applied on high courts? Are high courts supposed to follow the decision passed by Supreme Court? Tell me. Can the decision of Supreme Court be applied on high courts? Can we say like that if a decision is given by a Supreme Court, it shall be followed by all other courts? Yes, of course, because Supreme Court is a higher court. So higher court decisions are binding in the lower courts. Okay. The judges generally follow legal principles set by court of equal or higher authority in earlier similar cases. Okay. What is happening here? For example, if a decision is given by High Court, Rajasthan, and there is another High Court, Maharashtra. Hello, funny man. What is your name? So, if a decision is given by High Court, Rajasthan, if a decision is given by High Court, Rajasthan, will it be followed by High Court, Maharashtra? Yes, it can be. Because in case of court-made decisions, either the court should be of equal authority or the court should be of higher authority. Okay, Satyam? So basically what is happening here, if they are of same level courts, they will follow each other's decision, or if there is a higher level court, they will follow its decision in the similar cases. Okay, Pranav. So this is called doctrine of precedent. Precedent means the decision given by the court. So two principles we have studied. If a decision is given by a higher court, it will be followed in the lower courts also. And if decision is given by same level of court, we can follow that decision in the same cases. So if a decision is given by Maharashtra court in case of A and B, if same kind of case comes in the Rajasthan High Court can follow the same decision given by Maharashtra court. So when giving a judgment, what the judges should do? Judges should write all the facts of the case, the arguments of the party, and the reasoned decision on the basis of which the decision is made. All the reasons must be written in the decision. So let us write about precedents and common law. Common law is based on judicial precedents. Satyam, if you are taking one class every day, I think 1.5 months is enough. Judicial precedent. Precedent means decisions of court or decisions by judges. Now the first point is a precedent by higher court will apply on a lower court. Okay. The second thing is precedent can be followed if decision is given by court of same authority. Okay. The next thing is that a higher court can set aside the decision given by lower court. Now what is it? Let us understand. For example, there was a case in High Court and the High Court gave a decision in favor of A. Now, the similar kind of case came in Supreme Court. Supreme Court may ignore this decision of High Court and give decision as per the Supreme Court's own considerations, and that decision will be binding. So, a higher court can ignore the decisions given by a lower court, means it is not compulsory that a higher court will follow the same decision that is given by the lower court in similar cases. Supreme Court can override its own decision. That is also a power of Supreme Court. They can override their own decision. Means they can override their earlier decision and then now they want to give a new decision. Own precedent. Okay. So now please write those points. Precedents are important. Write those points. Once they are done, let me know about the precedent. Precedent means judicial decisions given by the judges, and those decisions can be followed by other courts. But we need to ensure that the case is similar, the facts are the similar, then only the same decision can be adopted. Can we go ahead, students? Okay, Pranav, you can, I am having a tea, you can continue writing. I am a big fan of tea. All right. Now, the key legal reasoning of the decision, the basis on which decision is given is known as ratio decidendi, means the reason behind a decision, and other comments and observations which are not in the actual reason of the decision, they are known as obiter dicta. So, ratio decidendi is a term we use for the reasons of giving a decision, reasons behind a decision. Now, these reasons are important, obviously. The other thing of the case, they are usually known as obiter dicta. Those are extra observations, extra comments of the court on the specific matter. So they are not important. This is very important, ratio decidendi, the basis on which decision is given. Also, the decisions do not bind the later court but may be used as a persuasive authority. It is not compulsory the later court will follow the same decision, but we can persuade them. That means we can convince them. Precedent will not be binding in a later case, means the previous decision of a court will not be binding in a similar case later if it was wrong per incurium. Wrong per incurium means if a previous decision was given without proper facts, without proper knowledge, that simply means the decision might have been wrong. In that case, that precedent will not be binding, because if previous decision was given without listening all the things, without considering all the facts, that cannot be binding in the future cases. Precedent will not apply when the fact of the case are materially different. It is also important when we are saying that one court's decision can be used in another court. That is only possible if facts of the two cases are similar. If the two cases are completely different, then we cannot follow the precedent. We have to listen the case completely and give our own decision so that it can be distinguished from those before the court in the later case. The previous decision of an earlier decision by a lower court may be subsequently overruled in another case decided at a higher level. Like I have given an example, if a decision is given by High Court and the case was of A and B, decision was given in favor of seller A. Okay. Now there is another case of Y and Z. Here Y is the seller. The case is exactly similar to the case of AB. Okay. Now there is Supreme Court. So it is not essential that Supreme Court will give decision in favor of Y only. Supreme Court can overrule the decision given in the lower courts, and once the Supreme Court give decision, it will become binding in the future cases. Why it will become binding? Because Supreme Court is the highest court. So earlier judgment is not changed. If Supreme Courts give a decision in favor of Z in this case, means Supreme Court is giving decision in favor of buyer. Does that mean the High Court's decision is changed? The answer is no. But obviously, now this decision will not be followed further, and now Supreme Court's decision will be followed in the future. Is this point clear? This point is very technical. This simply says that it is not necessary that a decision of lower court will be followed by the higher court. If higher court changes the decision, that doesn't mean lower court's decision will not be followed. Lower court's decision is changed, the lower court's decision in that case will remain same, but higher court's decision will now be followed in the future. Is this point clear? This is very technical point in this particular topic, that when a decision is given by High Court, let's say decision was given in favor of seller. Now same kind of case was present in front of Supreme Court, but Supreme Court wants to give the decision in favor of buyer. Now, those two cases in two persons are different, but in case of High Court, decision was in favor of seller. and now Supreme Court gave decision in favor of buyer. High Court decision will remain same as it is, but in case of future cases, Supreme Court's decision will be followed. Is that clear? A higher court means the Supreme Court can reverse a decision by a lower court on appeal. The earlier decision is nullified. So we have two things. There is an appeal and there is a changed decision. Now, what is appeal and what is changed decision? If High Court is giving decision in favor of A, then B can apply to Supreme Court for the same case. Supreme Court, we can appeal to the Supreme Court that listen my case again. I want you to listen and give the decision. So in this case, High Court's decision will be cancelled and Supreme Court will listen the case and Supreme Court's decision will be final. Changed decision means High Court gave a decision in favor of AB. This case is sorted. Now a new case is in front of Supreme Court. Supreme Court is hearing the case and changing the decision. Means High Court gave something else and Supreme Court is giving some other decision. So that is a changed decision. In case of appeal, the previous decision of the lower court is cancelled and Supreme Court's or higher court's decision will be final. So every statute is having a preamble. Preamble means the first page of statute that covers scope and object of the statute, the purpose for which the law is passed. Hello, Samar. So that is what preamble means. Interpretation. Interpretation means understanding the intention of legislature. Now, how the interpretation should be done? So interpretation's first rule is literal approach. Literal means you should understand the words in the language they are written. So first approach is literal approach. Judges first consider the ordinary meaning of words. If applying the law literally would lead to absurd, unjust or impractical result, they may move away from the strict meaning of the words. So literal approach simply means first of all you should give the meaning to the words which are written in the law. The second one is contextual approach. Contextual approach means words should not be read in isolation. You should read the entire context to ensure law is applied as intended. The third one is purposive approach. Purposive approach means we look at the purpose or object of law applying in a way that best achieve that purpose. So law should be interpreted in a manner where the purpose is achieved. So there are different approaches that courts can follow to interpret the legislation. Now, in some common law countries like United States, judges can also decide if law is constitutional. In some other country like UK, the parliament is having the supreme power. Like in India, parliament is having supreme power. When parliament is having sovereign or supreme power, so once a decision is passed by parliament, court cannot overrule it even if it is having any weakness, deficiency, flaws. Once a law is passed in parliament, court cannot overrule it. No parliament can pass a law that future parliaments cannot change. It is important. You cannot pass a law that future parliaments cannot change. Now, there is a question in my mind. Is there anything, is there any matter which can fall under civil law as well as criminal law? Do you think there are crimes which can fall under civil law as well as criminal law? answer, Pranav. There are matters which can fall under civil as well as criminal law. So that matter is known as double liability. Means there are certain matters which can fall under criminal case as well as civil case. For example, if there is a case of fraud, A has done a fraud against B. So it is a civil case if the fraud is between, means this is a dispute between individual. A has done a fraud with B. So B should get compensation for the same. That will be the civil case of the matter. Now, what is the criminal case saying? That A has committed a fraud against B. Now A can repeat this fraud with others. So that's why a criminal case should also be started against A. So here we can say double liability may arise for certain matter, but it is not necessary that matter will be listened in the same courts. Courts might differ, but there are certain scenarios where double liability may arise. All right, let's check your knowledge. Which of the following correctly pairs a legal system with the primary definition defining characteristics? Tell me the correct option here. The answer is C. Civil law is written constitution. Perfect. Civil law heavily relies on judicial precedent. No. Common law is formulated based on Quran. No. That is religious law. Originated from English legal thought. Not at all. Option C is the perfect combination. Perfect answer. Now we will be solving certain study hub question. Give me a minute. I am opening study hub for you. Just give me a minute. Let's solve some questions from ACCA Study Hub to understand the topics in a better manner. Not getting loaded. Wait for a minute. Here we go, students. The first question is, which of the following system determines the way in which society is governed? How the society is governed, which type of system determines it? Which option is correct option here? Option B, political system, perfect answer. This is the way, that's how society is governed, perfect. In which of the following system there is no separation of church and state? Where we find there is no separation of church and state? Tell me which option you seem is correct here. Theocracy, perfect answer. In common law and civil law system, the judges has power to do which of the following? You have to understand the difference between legislature, executive, and judicial wing. So, judicial wing can only interpret law, resolve the disputes. You need to ensure that you do not select an option which is the power of legislative wing. Can we see, review, and invalidate the actions of government? All right. Administer the state bureaucracy, signing of new law, that is the power of parliament, deciding and passing new law, power of parliament. Option C is perfect. Review and invalidate the actions of government. Very true. Sharia law is an example of which of the following Sharia law is found in your Saudi Arabia, Pakistan, Afghanistan, such kind of countries. So let me know, Sharia law is an example of which of the following. Very easy question to answer. Perfect answer is religious. The next question, in a criminal case, on whose behalf the prosecution will act? Very easy question to answer. State is a perfect answer. Who will file the case against the accused? Which of the following is the term used to describe the standard of proof in a criminal case? We have discussed this. In criminal case, we need high standard of proof. In case of civil cases, low standard of proof will also work. Tell me the standard of proof should be high standard. High standard means perfect answer is beyond reasonable doubt. Perfect on the balance of probability. It is in civil cases. Perfect answer. Which of the following statement about legal liability is correct? We have just discussed this topic. Tell me which statement is correct. First is true, second is false. Okay. So, one only is correct. Perfect answer. Some cases give rise to civil and criminal liability. In case of double liability, it is not essential that all the cases will be heard in the same court. The Roman legal principle that law should be contained in codified written collection of rules and regulation. It is very easy question. Codified law, written rules and regulation. Which type of legal system is it? Civil law, perfect answer. Codified law, written constitution, civil law. In a civil law system, what is the role of judges? Very easy question to answer. The role of judges is very limited because everything is already written. To interpret the law, to apply and enforce the law, or to, sorry, this was to apply and enforce the law because law is already properly written. You cannot give much interpretation to the law. You cannot fill the gaps. You can only enforce the already written law. Option C is correct. Jury will most likely sit in which of the following legal cases? Jury means group of judges. And in which case we will be needing group of judges? Option C, judicial review of legality of a new law. Okay. Civil claim for damages or criminal prosecution for murder. In which cases you will be having jury? Yes, it should be option A. Jury shall be sitting in case of criminal cases, murder cases. In severe cases, we will be needing more than one judge. Equity is a feature of which type of law? What do you think is the correct answer of this? Equity is a feature of which type of law? Civil law, common law, criminal law, or international treaties? Will it be common law? Because common law is based on principle of natural justice, principle of equity, or past decisions. What principle prevent the judges from overruling legislation? Why the judges cannot overrule the law? A very good question to understand. Why the judges cannot overrule the law? What is the main reason behind it? Why judges cannot overrule law? No, it is parliament is sovereign. Parliament is supreme. That is the reason judges cannot overrule the law, because parliament is the legislative body and legislative body is supreme. That's why judges cannot overrule the legislation passed by the parliament. So that is the reason parliament is sovereign, parliament is supreme. Okay, now next question. There is a one question, yes. In relation to the separation of power, which of the following is an example of action by executive? There are three wings of government, we know: legislative, executive, and judicial. Now we have to select an option which will fall under executive wing of government. Tell me what will be the role of executive wing of government. Now don't worry, this class will be ended shortly. Taking the decision to prosecute someone for criminal offense. Let's check whether the answer is correct. Perfect. Dekho. First is taking the decision if they want to file a case against someone. Second is preliminary reading of draft law, that will be done by legislative wing. If a new law is to be made, there will be a draft of the new law and that will be taken care of by legislative wing. The former enactment of a new law, that is passing of a new law, that is also done by the legal legislative wing. A ruling that action of minister was illegal, that is done by the courts, and courts fall under judicial wing. That means only option 1 is left for us to identify, and that is the disease, that is the work of executive wing. Which of the following statement is always correct in relation to the principle of judicial precedents? Judicial precedents means decisions given by the court. Now we have to identify a statement which should always be correct. So there are statements which are sometimes correct but not always correct. You have to select a statement which should be always correct. And for that, you need to connect with the team. They will be guiding you. They are binding on lower court or court of same level. They have superiority over delegated legislation. They no longer apply if subsequent legislation enacts the law to the contrary. Option C is the perfect answer. Why it is perfect? Because option A is half correct. They are not always binding. Sometimes they are binding, sometimes they are not. Are they having superiority over delegated legislation? The answer is no. They no longer apply, yes. If the law changes in future, the old decision will no longer apply. The new decisions will be made according to the new law. That's it, friends. Here we have studied a topic. Let us have a quick recap of what we have studied today. So, our topic of discussion started from the types of your economy. We have market economy, we have mixed economy, we have planned economy. Market economy is run by market forces, mixed economy is by market forces and government, planned economy is by government. The second topic was types of political system, how the society is governed. We started with monarchy, that is a society governed by a ruler or sultan. Then there was democracy, it is elections by people where there will be a ruling government. Totalitarianism, no opposition, one single political party deciding all the aspects of life. Anarchy, there is no need of government. Theocracy, there is no difference between the government and the church. And republic, the governance is by a president who is elected. Westminster is a combination of monarchy plus democracy, and those were the models we have studied under the types of political system. Then we started with the legal system. In government we have three wings: legislative, executive and judicial. Legislative wing makes the law. Yes, definitely, Pranav, definitely it is possible. Executive wings implements the law, judicial wings resolve the disputes, gives the interpretation. Then we discussed about types of legal system. We have common law, civil law, religious law. Civil law is purely written codes, and common law is based on equity, natural justice, and precedents. And religious law is based on religious beliefs. And then we discussed the branches of law: criminal branch and civil branch. Criminal branch covers the serious cases which government wants to stop and punish the criminal. And here the case is filed by the government. Proof is beyond the reasonable doubts. In civil cases, we just need a dispute resolution between the parties. Compensation can be granted, specific performance can be granted, and proof is based on probabilities. All right. Then we discussed about the precedents. Precedents are decisions by the courts, and these decisions should be based on the proper facts. Reasons shall be mentioned. Ratio decidendum should be proper. If decisions are not made properly, it will be per incurium, and such decisions will not be binding in future. A court's decision given by a higher court is binding on the lower courts, but a decision of same authority are persuasive, means you can follow that decision. Decisions are followed only if the cases are similar. If cases are different, then precedents are not followed. A higher court can ignore the decision of the lower court and give its own decision. A supreme court can override its own decision which it had previously given. So those are the principles of precedents which are given by the courts. The interpretation: in case of civil law, judges are having limited power because everything is written. You just enforce the law. You are not supposed to add on the things or give the interpretation. So that happens in case of civil law only. All right. In interpretation, we firstly follow the literal approach, means words should be understood in the ordinary sense, and then we look for purposive approach, an interpretation which fulfills the purpose of the legislature. So those were the topics. Certain kind of actions bring double liability, that is similar, civil as well as criminal liability. So those were the topics that we have covered in today's session. I hope you understood those topics well. And we can conclude this session here if there are no doubts from your end. Can we conclude this session here? I hope there are no doubts from your end. Thank you so much, everyone, for joining the class. Thank you. Half spoon only. Thanks for asking, Pranav. Bye bye. Cha cha. Take care.